Melania Trump just testified under oath. After years of calculated silence, the former First Lady sat in a federal courtroom, raised her right hand, and delivered testimony so devastating that the lead prosecutor stopped mid-question. A total of 14 hours of sealed depositions have now been partially unsealed, and what they reveal is unlike anything we've seen in modern American history. This isn't a bitter ex making accusations from the sidelines. This is a sitting witness, still legally married to the defendant, providing first-hand accounts of financial decisions, document handling, and private conversations that directly contradict sworn statements Trump made to investigators. When the person who shared your bedroom for 2 decades takes the stand against you, the usual playbook of denial and deflection collapses entirely. Hit that subscribe button right now because you won't want to miss any of the videos I release. So, what drove Melania Trump to break her silence in the most dramatic way possible? According to sources familiar with the proceedings, she was served with a federal subpoena on January 9, 2026, compelling her testimony in connection with the ongoing investigation into financial disclosures and document retention. Legal analysts say her cooperation wasn't voluntary in the traditional sense, but that once under oath, the scope of what she revealed went far beyond what prosecutors had anticipated. This isn't just another political controversy or routine legal proceeding. This strikes at the very heart of Trump's defense strategy, which has relied for years on the assumption that his inner circle would never break ranks. And believe me, when the former First Lady of the United States provides testimony that contradicts a defendant's sworn statements, something seismic has just shifted in the case. Here's the full picture of what's been unfolding. Tensions between Melania Trump and the former president's legal team have been building quietly for over a year, fueled by disputes over financial arrangements, disagreements about legal strategy, and what sources describe as a fundamental breach of trust following the Mar-a-Lago document seizure. But everything escalated on January 14, 2026, when Melania appeared before Judge Arthur Engoron's extended panel in a sealed session at the federal courthouse in Lower Manhattan. She arrived without any of Trump's attorneys present, accompanied only by her personal counsel, a detail that sent immediate shockwaves through the legal community. Court filings unsealed on January 19th reveal she provided detailed testimony about financial documents she personally witnessed being moved, altered, or destroyed between 2021 and 2023. Smash that like button if this is making sense so far. Here's where it really gets serious. When prosecutors reviewed the initial transcripts of Melania's testimony, they recognized immediately that her statements crossed a critical evidentiary threshold. She wasn't offering opinions or secondhand accounts. She was providing dates, locations, and direct quotes from private conversations. And let's be honest for a moment, a spouse testifying in a federal proceeding against their partner is extraordinarily rare. It doesn't happen over political disagreements or minor legal disputes. It happens when someone believes they have a legal and moral obligation to tell the truth, regardless of the personal consequences. Here's what multiple sources say happened during the most critical moments of her testimony. On January 14th, Melania entered the courtroom at 9:15 in the morning through a private entrance to avoid media. The proceedings were sealed, but portions of the transcript were released 5 days later following a motion by a coalition of news organizations. Sources who reviewed the full transcript told reporters that the lead prosecutor, Assistant U.S. Attorney Catherine Marquez, began with routine questions about Melania's knowledge of financial record-keeping at the Trump Organization. Melania answered calmly and precisely for the first 2 hours. Then came the moment that changed everything. Marquez asked about a specific evening in November 2022, approximately 3 weeks after the midterm elections. According to the unsealed portions, Melania described walking into a private office at Mar-a-Lago and witnessing documents being placed into boxes by staff members she identified by name. When asked what Trump said to her about those documents, Melania paused for 11 seconds. The court reporter noted the pause in the transcript. Then she responded with words that, according to 3 attorneys present, caused the entire room to fall silent. She stated that he told her those papers were worthless copies that nobody would ever ask about, and that he said the originals were already where they needed to be. That single statement directly contradicts Trump's sworn declaration that he had no knowledge of documents being moved or reorganized after leaving office. The implications are staggering. Drop a comment right now if you saw this coming. I read every single one. Now things get absolutely explosive. After the document exchange testimony, Marquez shifted to financial disclosures. Melania described being present during conversations where asset valuations were discussed, specifically regarding properties in New York and Florida. She testified that she heard Trump instruct his chief financial officer to use what he called creative numbers for insurance purposes, adding that she remembered the phrase because she asked what it meant and was told not to worry about it. Reporters who obtained the unsealed transcript described Marquez as visibly startled by the specificity of Melania's recollections. When Trump's defense attorney attempted to object on spousal privilege grounds, Judge Engoron ruled that the privilege had been partially waived by Trump's own prior statements in deposition, where he had referenced conversations with his wife to support his defense. That's when it became clear this isn't just another chapter in Trump's legal battles. The bombshell moment came when Melania was asked whether she had ever discussed her testimony with Trump or his attorneys prior to appearing. She responded clearly and without hesitation that she had not, and that her personal attorney had advised her to have no contact with the defense team regarding the substance of her testimony. Legal analysts say this answer demolished any future claim that her testimony was coordinated or coached. This move sent shockwaves through Washington and the legal world simultaneously. When a spouse provides testimony this specific and this damaging without coordination with the defense, it signals that the defendant's inner circle has fractured beyond repair. The usual claims of a partisan witch hunt collapse when the witness is the defendant's own wife. This isn't the first time devastating testimony from an insider has reshaped a presidential legal crisis. Think back to John Dean during Watergate. Dean, Nixon's own White House counsel, provided testimony that directly implicated the president in the cover-up. His decision to cooperate transformed the investigation from a political dispute into an existential threat to the presidency. Nixon resigned within 14 months of Dean's testimony. Then there was Monica Lewinsky's grand jury testimony during the Clinton investigation. While the circumstances were vastly different, the principle was identical. When someone from the innermost circle provides sworn testimony that contradicts the president's public statements, the entire defense architecture crumbles. The key difference here is that Melania's testimony relates not to personal misconduct, but to potential financial fraud and obstruction, charges that carry severe criminal penalties. Subscribe immediately if you haven't yet. This content doesn't exist anywhere else. And let's not forget Michael Cohen, Trump's former personal attorney, who provided congressional testimony in 2019 that detailed financial manipulation and hush money payments. Cohen's testimony was powerful, but it was also easy to dismiss because he was a convicted felon with an obvious grudge. Melania carries none of that baggage. She has no criminal record, no cooperation agreement, and no apparent motive to fabricate. Now, however, the dynamic has fundamentally changed. This time, the witness isn't a disgruntled former employee or a political opponent. It's the person who knows Trump's private world better than anyone alive. The pattern is clear. When insiders break ranks with specific sworn testimony, legal defenses built on denial become unsustainable. So what specifically in Melania's testimony has legal experts calling this a potential turning point? According to constitutional law scholars and former federal prosecutors who reviewed the unsealed portions, her statements established three critical elements. First, direct knowledge of document handling that contradicts Trump's sworn statements. Second, firsthand witness accounts of conversations about financial valuations that suggest intent. And third, testimony about the timing and circumstances of these events that aligns precisely with documentary evidence prosecutors already possess. Here's the kicker. The unsealed transcript reveals that Melania provided specific dates for 7 separate conversations she overheard between Trump and his financial team, each corresponding to periods when, according to prosecutors, fraudulent valuations were submitted to banks and insurance companies. This wasn't vague recollection. It was precise, dated testimony that prosecutors can cross-reference with existing records. Don't go anywhere. The most explosive part is coming next. And here's what should alarm everyone, regardless of political affiliation. This isn't just about one case or one family's internal conflicts. If a president's own spouse can provide evidence of financial fraud and document obstruction under oath, it demolishes the entire framework of executive secrecy that Trump's defense has relied upon. Once the innermost circle breaks, every conversation, every decision, every private moment becomes potential evidence. That precedent extends far beyond this case. This puts Trump's legal team in a nearly impossible position. On one side, they need to discredit Melania's testimony to protect their client. That means attacking the credibility and motives of the defendant's own wife in open court, a strategy that risks alienating jurors and generating devastating media coverage. They would have to portray the former First Lady as either a liar or someone so detached from her husband's affairs that her testimony is unreliable. Neither characterization serves Trump's interests. On the other side, they must somehow reconcile Trump's sworn statements with Melania's contradictory testimony. If his own wife says she witnessed document handling and heard conversations about financial valuations, his blanket denials become almost impossible to maintain. And here's the tricky part. There's no credible middle ground. Either Melania is telling the truth, in which case Trump's sworn statements are demonstrably false, or she's fabricating detailed testimony under penalty of perjury with no apparent motive, which would require believing that a woman with no criminal history and no cooperation deal decided to risk federal perjury charges to harm her own husband. Legal analysts say neither scenario benefits the defense. Legal and political analysts are calling this a potential inflection point in the case. Lawrence Tribe, Harvard law professor and constitutional scholar, told MSNBC that spousal testimony of this specificity is virtually impossible to overcome in a federal proceeding. He explained that juries instinctively understand that a wife doesn't testify against her husband lightly, and that the emotional weight of her presence on the stand alone creates a credibility presumption that's extraordinarily difficult to counter. Do me a favor and slam that like button because it genuinely helps this video reach more people. Even Jonathan Turley, George Washington University law professor and frequent defender of presidential authority, acknowledged that the testimony creates serious evidentiary challenges for the defense. He emphasized that regardless of political perspective, when a spouse provides specific dated testimony that contradicts a defendant's sworn statements, the legal implications are severe and the defense options narrow considerably. A former federal prosecutor, Andrew Weissman, who served on the Mueller team, added that these statements could independently support charges of making false statements to federal investigators. He pointed out that Melania's testimony doesn't just weaken Trump's defense. It potentially establishes the criminal intent element that prosecutors need to prove, which is knowledge that statements were false at the time they were made. So let's break down what this could mean going forward. First, the immediate legal impact is devastating. Melania's testimony creates a direct conflict with Trump's sworn depositions. In federal proceedings, when two sworn statements from closely connected witnesses contradict each other, prosecutors can use the discrepancy to establish consciousness of guilt. Trump's legal team will be forced to address this conflict in pretrial motions, and any attempt to exclude Melania's testimony will generate a legal battle that itself becomes damaging. Second, the political fallout is already unfolding. Republican leaders who have stood by Trump through every prior legal challenge are notably silent. A poll conducted by Reuters within 48 hours of the transcript's partial release found that 34% of Republican voters said the spousal testimony made them less confident in Trump's legal position. Among independent voters, that number jumped to 61%. Those are devastating figures for a defense that depends on maintaining public support to generate political pressure against prosecution. Finally, the institutional implications are profound. This testimony sets a precedent for how federal investigations handle evidence from presidential spouses. Legal scholars are already debating whether the partial waiver of spousal privilege in this case could be applied more broadly. If so, it fundamentally changes the calculation for future presidents about what conversations remain privileged and which become fair game for prosecutors. Drop a comment below with your thoughts. I'm genuinely curious to see your perspective. But beyond the immediate legal and political fallout, this is really about something fundamental to our system of justice. The principle that no one is above the law has been tested repeatedly in recent years. Melania's testimony represents perhaps the most dramatic test yet because it comes from the one person everyone assumed would never speak. If the evidence she provided under oath is accurate, it means the defense strategy built around denial and secrecy has been permanently breached. The question is no longer whether prosecutors have enough evidence. It's whether the justice system has the institutional will to act on it. This situation is causing sheer panic within Trump's inner circle. Reports from CNN indicate that senior advisors held 3 separate emergency calls within hours of the transcript's release. Some argued for an aggressive public campaign to discredit Melania's motives, suggesting she was pressured by prosecutors or manipulated by her own attorneys. Others warned that attacking the former First Lady would be catastrophic, with female voters and suburban independents demographics already slipping away. The team is fracturing in real time, torn between the instinct to fight and the recognition that this witness cannot be easily destroyed. Meanwhile, Trump's most loyal supporters online are struggling to process the development. Social media is flooded with conspiracy theories claiming Melania was coerced, threatened, or replaced by a body double. The base that defended Trump through 2 impeachments, multiple indictments, and a conviction is now confronting the one scenario they never prepared for: the person closest to him providing sworn evidence against him. Things escalated further when Trump responded with a series of posts calling the testimony a disgrace and claiming Melania was manipulated by radical prosecutors who threatened her immigration status, a claim her attorneys immediately and categorically denied. He called the unsealed transcript cherry-picked and taken out of context without specifying which portions were inaccurate. Stay with me. What comes next will completely change how you view the situation. Here's what makes it even more devastating for the defense. Trump's response essentially drew more attention to the testimony rather than undermining it. Instead of providing specific factual rebuttals to Melania's statements, the reaction was pure fury directed at the process and the people involved. When your defense against sworn testimony is attacking the witness's motives rather than disputing the facts she presented, legal experts say you've effectively conceded the substance. Former federal judge Nancy Gertner told the New York Times that the defendant's public response was the worst possible strategy, noting that it amplified the testimony's significance while providing no factual counter-narrative. This goes far beyond a single legal proceeding or a family dispute playing out in public. It's about whether the most powerful person in the country can maintain a wall of silence around their private conduct when that conduct intersects with potential federal crimes. If there are no consequences for the contradictions between Trump's sworn statements and Melania's testimony, it signals that truthfulness under oath is optional for those with enough power and political support. It's not just about this case, it's about whether sworn testimony from the highest levels means anything at all. If this blows your mind, hit that like button right now. Here's where things stand right now. A former First Lady has provided 14 hours of sworn testimony that directly contradicts her husband's statements to federal investigators regarding document handling, financial disclosures, and private conversations about asset valuations. Legal experts across the political spectrum agree the testimony creates severe, potentially insurmountable problems for the defense. This is no longer a matter of partisan politics or prosecutorial overreach. It's about whether sworn evidence from the most credible possible insider witness will be allowed to speak for itself. When the person who stood beside a president for 2 decades raises her right hand and tells a federal court what she saw and heard, we've entered territory that has no precedent in American legal history. If there are no consequences, it sets a chilling precedent. Future presidents and their allies will know that even sworn testimony from the innermost circle can be dismissed, discredited, and ignored. Keep a close eye on this story. Additional portions of the transcript are expected to be released following a hearing on February 24th. Trump's legal team has until March 3rd to file motions challenging the admissibility of the testimony. And legal observers across the country are watching closely to see whether this evidence changes the trajectory of the case or whether it becomes another extraordinary moment that ultimately leads nowhere. Before we go any further, smash that subscribe button so you never miss content like this. Here's the reality. The former First Lady just put her credibility, her privacy, and her safety on the line by telling a federal court what she witnessed. Military families, law enforcement officers, and ordinary Americans who believe in the justice system are watching to see if that sacrifice matters. Meanwhile, the defense is scrambling, the political landscape is shifting, and more sealed testimony may still be coming. This isn't just another news cycle that will fade away. This is a constitutional reckoning unfolding in real time. What happens next could determine whether sworn testimony still carries the weight it was meant to carry in our system of justice. The evidence is on the record, the testimony has been given. Now we wait to see if accountability still holds any weight in America. The stakes have never been higher, the testimony has never been more personal, and the consequences have never been more immediate. Pause for a second and hit that like button if you're finding value in this coverage.